8 days ago, Dr. Anthony Fauci sat before this committee in the witness chair under subpoena for conduct covered by the President Biden's full and unconditional pardon, reaching back to 2014. Dr. Fauci faced no risk of federal prosecution. All he had to do was tell the truth. More than 100 times, though, he refused. The chair ruled that Dr. Fauci's assertion of the Fifth Amendment privilege was unsupported in light of the pardon and the testimony he offered in his opening statement. The chair directed Anthony Fauci to answer. He refused again. That is what we are voting on today. Not his opinions, not his policies, not anything he said from a podium 6 years ago. We are voting on whether a witness who has received the benefit of a sweeping federal pardon can be ordered by this committee to answer questions and then defy that order without consequence. More than 1 million Americans died from COVID. Many of them died alone. Workers were forced to choose between a mandate and a job they needed. Businesses closed and never reopened. Children lost years of school they will never get back. Americans lost the freedom to work, to worship, and to decide what went into their own bodies. Nothing we do today can undo those losses, but silence does not honor them either. This committee and the American people have a right to know why Dr. Fauci's agency funded dangerous research at the Wuhan Institute of Virology and what role he played in approving and overseeing it. Why he told his colleagues to delete emails. Why he told them to delete emails and then delete the deleted file. What was he told in January 2020? What was said on those calls? What his agency did with and for the intelligence community, and whether, knowing what he knows now, he still believes that the risks were worth taking. Documents tell only part of the story. Many of these questions can be answered only by Dr. Fauci. He answered none of them. There will be another pandemic. The time to determine which legislative reforms are necessary to ensure that the mistakes of the past are not repeated is now, not later. This committee passed the Bipartisan Risky Research Review Act to strengthen oversight of dangerous life sciences research funded by the federal government to address failures exposed by the COVID-19 pandemic. But Congress cannot determine what additional reforms are necessary until it fully understands what remains unanswered. Holding a witness in contempt is a serious thing, and it should be rare. But the contempt power exists for precisely this circumstance. Oversight is not a courtesy this committee extends or a favor a former official grants us. It is a constitutional obligation. And when voluntary cooperation ends, Congress must be able to compel compliance with its lawful demands. That is Congress's compulsory instrument. A subpoena is not an invitation. A subpoena with no consequence is not a subpoena. It's a suggestion. Seeking the truth is not a witch hunt. Accountability is not vengeance. Accountability is what stands between the American people and a repeat of the mistakes and the very real consequences of the past.
The reason I asked those questions was precisely to test the good faith nature of his invocation of the Fifth Amendment, because as the lawyers in the room will know, the invocation of the Fifth Amendment, particularly in a context where immunity has already been obtained, Dr. Fauci has full immunity, he has a full and unconditional pardon for a period of some 11 years. In that context, the assertion of a Fifth Amendment privilege only adheres to those instances where the witness has a reasonable fear of future prosecution, and it must be tailored to any such fear. And the fact that he wouldn't answer questions about the tie he was wearing or the color of the carpet or the day of the week, Senator Paul asked him about, did he have a folder in front of him? He wouldn't answer that. Betrays the fact that his invocation of the Fifth Amendment wasn't tailored to anything. It was a predetermined, premeditated design to evade this committee's questions on any subject, including emphatically those for which he has a pardon. And the United States Supreme Court has been clear for over a century, dating back to 1896, that when a witness has received immunity, he may not stand upon his privilege. And multiple courts of appeals from the United States, including the United States Supreme Court in the Castigar case, has says that, I'm going to quote now, a witness must reasonably believe that his statements could be used in criminal prosecution or could lead to other evidence that might be so used. The court has also said that the danger must be real and appreciable. It must not be one of imaginary and unsubstantial character. All that to say that I think it's pretty clear, given Dr. Fauci's 111 invocations of the Fifth Amendment, including questions that he could have no fear of prosecution on. He's not going to get prosecuted for the color of his tie. Shows that he had no interest and no intention of answering any of our questions, and that is an abuse of the privilege. There's no privilege for any of that, and I think there was no good faith attempt to invoke.
Mr. Chairman, I really need.
Well, let me finish. Is that
I've let you go on, and we're gonna get to the votes.
Well, I understand that, but I don't remember ever cutting you off when you were ranking member, and I've always respected your rights, and I'll continue to respect your rights. I would just hope that you would offer that same courtesy to us because things do change and precedent is important. And I would urge my colleagues to table this resolution until we have a chance to look at the information, as has been the practice of this committee for as long as this committee has been in existence.
For the record, Anthony Fauci refused a voluntary private deposition, and that's why he was brought in under subpoena.
Because it was going to be one-sided.
Don't interrupt the
Because
chair.
it was gonna be
Don't interrupt the chair. With regard to access to records, there has been, seeing no other motions, the question is on reporting of an original resolution regarding contempt of Congress. The clerk will call the roll.
Senator Johnson.
Yes.
Senator Langford.
Aye.
Senator Scott.
Yes.
Senator Hawley.
Aye.
Senator Moreno.
On behalf of the millions of people harmed by Anthony Fauci, resoundingly yes.
Senator Ernst. Aye. Senator Moody. Aye. Senator Peters.
No.
Senator Hassan.
No.
Senator Blumenthal. No. Senator Fetterman. No. Senator Kim. No. Senator Gallego.
No by proxy.
Senator Slotkin.
No by proxy.
Senator Paul.
Yes.
Mr. Chairman, on the vote of those present, the yeas are 8, the nays are 5. On the vote by proxy, and for the record only, the yeas are 0, the nays are 2. On this vote, the yeas are 8, the nays are 5, and the motion is agreed to.
Mr. Chairman, pursuant
I
to
haven't
committee rule.
recognized you.
Mr. Chairman.
We've had ample remarks on this. The chair will limit remarks to 2 minutes. I will